Good day, Crime Talk aficionados. We have another great show for you today. First, it is time to try this case. That is the prosecutor's position on the motion to continue filed by Bryan Kohberger. The final defense witness is testifying in day 31 of the Karen Reed trial. Lori Vallow tries again to remove the judge in her case mid-trial. How did that go? Sean Combs, he liked getting freaky weird. Some low-budget YouTubers show how not to resolve their disputes. A school counselor finds out her fate in court. We have This Day in Legal History, our quote of the day regarding plea bargains, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do. Leave me a comment below and hit that little bell for notifications. And remember, you can check us out on any of your favorite podcasting apps. Now, before we get started, go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you'll be able to do as many background searches on anyone here in the United States that your heart desires. Anyone, ladies and gentlemen. And you're going to get a report that is prepared and emailed to you literally while you wait. It's going to have all types of information, phone numbers, email addresses, social media presence. It's going to have everything that you want to know about somebody. But wait, there's more. That's right. You're going to find out if they're married. Are they divorced? Do they have debts? Do they have liens against them? Do they have a criminal history? And yes, are they on one of those registries you hear so much about? Go to crimetalksearch.com. Find out whether it's somebody coming into your life or whether it is somebody that's in your life, but maybe you're just not sure. Go check them out. You're going to be happy that you did. Remember, knowledge is power, and it could potentially save your life. All right, let's go ahead and get to the docket today for Wednesday, June 11th, 2025. And first on the docket, like I said, it is time to try this case. I could not agree more. Anyway, the Latah County prosecutors have formally filed their motion in opposition to the Bryan Kohberger defense team and their motion to continue the trial, which is scheduled there in Ada County for the alleged murder of the 4 University of Idaho students. Now, the state argues that Kohberger's request for an unspecified delay lacks sufficient justification, citing the extensive preparation already undertaken by the defense, the rights of the victim's family to a timely trial, and the unlikelihood that delaying the trial would mitigate challenges posed by intense media coverage. Now, for those who don't know, Bryan Kohberger was arrested back in December of 2022 and indicted in May of 2023 for the November 2022 killings. Now, the case has moved from Latah County to Ada County due to significant pretrial publicity, as well as logistical concerns. And then on October 9th of 2024, the court issued a scheduling order setting deadlines for pretrial motions and expert disclosures, which Kohberger's defense team has met without requesting any extensions along the way. These disclosures include 6 expert reports for the penalty phase, over 2,100 pages for mitigation materials, and 55 potential penalty phase witnesses and 132 exhibits. So, the prosecutor notes that despite complying with these deadlines, Kohberger's defense recently filed a motion to continue the trial, claiming that their mitigation investigation remains incomplete. Now, the state's opposition, which was filed on June 5th by the prosecutors in this particular case, contend that the defense has had ample time to investigate and has had ample resources to prepare, and a further delay is completely unwarranted. Now, they also note that the arguments that the defense raises are insufficient. Adequate defense preparation is what the Kohberger team has argued. And the state asserts that Kohberger's defense team, comprising 3 appointed attorneys, 2 investigators, a mitigation specialist, and support from the 1st District Public Defender's Office, has conducted a thorough investigation. The defense has disclosed extensive materials, including reports from 18 experts. 6 of those are penalty phase experts, with 5 focusing on mental health issues alone. They've produced over 2,500 photos and videos and 3,500 pages of investigative documents. The state argues that the defense claim of needing more time for a social history investigation is nothing more than speculative, as experts have already examined Kohberger's medical, mental health, and family history in detail, and they've diagnosed him with autism, OCD, and ADHD, and the state cites that Idaho Supreme Court precedent, noting that counsel is not required to investigate a defendant's entire life to provide an adequate defense. Now, the state also emphasizes that the Idaho Constitution's Victims' Rights Amendment, which grant victims, including the families of homicide victims, the right to a timely disposition of the case. And with nearly 2.5 years having passed since the Kohberger arrest, the state argues that any further delay would infringe on those rights. And the prosecution contends that Kohberger's motion filed after the discovery deadlines and after the pretrial conference is untimely and lacks specific evidence of prejudice that would justify postponing the trial. Now, Kohberger's motion partly relies on intense media coverage, including the recent Dateline episode that revealed non-public evidence to argue that a delay would allow publicity to dissipate. Now, the state counters that delaying the trial is unlikely to reduce media attention, given the case's high-profile ongoing coverage and such as annual stories marking the anniversaries of the murders. And so the prosecution highlights the court's robust jury selection process designed to identify impartial jurors despite widespread publicity is sufficient to ensure a fair trial. They also cite the Idaho and the United States Supreme Court precedent that states and argues that the ability to seat an impartial jury rather than the volume of media coverage determines the fairness. The state also criticizes the defense motion for failing to specify what additional evidence or investigative steps are needed by them. An ex parte motion filed by the defense, which the state was not permitted to review, purportedly outlines these needs, but the prosecution argues that the public record demonstrates that the defense is ready. The state requests that if the court finds merit in the ex parte filing, it be allowed to respond to any specific issues raised. Now, under Idaho law, trial courts have very broad discretion to grant or deny motions to continue, with appellate courts reviewing such a decision under an abuse of discretion standard, which is very hard to overturn on appeal. Now, a denial violates due process only if it is arbitrary and prejudices the defendant's substantial rights. And the state argues that Kohberger's motion does not meet this threshold, as it relies on speculative claims rather than concrete evidence of prejudice. Now, the prosecution also notes that non-binding ABA guidelines cited by the defense have been rejected by the Idaho courts as a standard for effective counsel, and that the defense's work already aligns with these guidelines. Now, the court's decision on Kohberger's motion will determine whether obviously the trial proceeds as scheduled or ultimately is delayed yet again. This is going to potentially affect the victims' families, the Ada County judicial system, and the public perception of the case. Now, the state's opposition underscores a commitment to balancing the defendant's due process rights with the victim's rights and the need for judicial efficiency in a case that has garnered obviously national attention. So, bottom line is, ladies and gentlemen, the judge has the discretion. If he wants to grant a continuance, he can. I think he'd be hard pressed to do so. If he wants to deny it, he is totally safe in doing so. The defense has had more than sufficient time to do what they need to do. And at the end of that motion, the state actually lists the ABA standards and shows exactly that the defense has complied with those ABA standards, which are not a requirement in the state of Idaho, but it's a reference point as it relates to effective assistance of counsel. We talked about this last night, and if you want to read, I read the entire motion verbatim yesterday. This is my summary of it today. But the essence of the motion is basically, we need more time, Judge, and well, we really can't tell you why, at least not to the public anyway. I know there's allegations of this third party culprit, but there's nothing been produced, so we can't rely upon that. Now, we'll see. We brought you the story the other day. Something big's happening. There's a stay to the appeal. So we'll have to wait and see what that is about, because obviously we don't have access to it. But staying in order usually means that there is going to be an appeal of some type, and we'll see what that is. We'll be monitoring those files and court records as they become available. But I am of the position of the prosecutors in this particular case. This case needs to be tried. 2.5 years is more than sufficient time to prepare, given the experienced attorneys and the team that they have assembled to get this job done. Next on the docket, Andrew Rentschler testifies in the Karen Reed trial. That's right. Today, the Karen Reed trial resumed with the defense crash expert Andrew Rentschler from ARCA, taking the stand to continue his testimony. Now, defense attorney Alan Jackson began by questioning the expert about a PowerPoint presentation he had prepared to outline his analysis of the case. Now, Mr. Rentschler explained that his investigation aimed to evaluate the evidence, particularly regarding the theory of what occurred. However, the prosecutor objected multiple times to the phrasing of Jackson's questioning, leading the judge to sustain the objections. Within 5 minutes, the judge called for a first sidebar of the day. Now, Jackson asked the expert, Mr. Rentschler, if ARCA had reviewed testing conducted by Aperture in connection with this case. The expert confirmed he had performed a biomechanical analysis of John O'Keefe's diagnosed injuries, examining how his body moved and whether he was struck by Reed's Lexus SUV. Now, during this testimony, Mr. Rentschler took a moment to wish his son a happy 10th birthday, an action that, let's just say, upset the court. Completely unprofessional. I cannot believe anybody would do that. If I was a judge, I would have kicked him out of my courtroom and said, move along, you're done. Anyway, Mr. Rentschler was testifying about O'Keefe's injuries, emphasizing that O'Keefe's arm had only superficial abrasions and not lacerations and no indications of fracture or trauma to the arm bone. Now, he stressed the importance of actually identifying the injury for proper analysis and noted that he examined physical evidence, including O'Keefe's sweatshirt. Now, there was another sidebar. It was called as Jackson continued questioning about Mr. Rentschler about his PowerPoint analysis. Anyway, the expert elaborated on the injuries to O'Keefe's arm, noting that 36 superficial abrasions, but only 9 defects on the right sleeve of O'Keefe's sweatshirt, as the Aperture report concluded. He also concluded that the abrasions were not consistent with the striking taillight of Reed's SUV, as the number of abrasions did not align with the defects in the sweatshirt. He said there was no evidence of dislocation or broken bones in O'Keefe's right arm. He argued that it would be physically impossible for broken taillight pieces to move differently from O'Keefe's arm, given the forward motion of the taillight. He argued that it would be physically impossible for broken taillight pieces to move differently from O'Keefe's arm, given the forward motion of the taillight and O'Keefe's diagonal movement. He described a 29-mile-per-hour test he conducted on a dummy using the SUV similar to Reed's, which showed extensive damage to the vehicle's rear and a straight back trajectory for the dummy, evidence inconsistent with O'Keefe's case. Now, Mr. Rentschler concluded that the kinematic of O'Keefe's right arm were not consistent with fracturing the taillight above or sustaining the observed abrasions. The expert continued that O'Keefe's injuries were not consistent with a vehicle strike. He cited tests showing extensive leg damage or dummies, whereas O'Keefe had no broken leg bones. He also dismissed the 1979 article referenced in Aperture's report, which claimed that the head was the most commonly injured body region in pedestrian impacts, noting it's irrelevant since modern SUVs were not manufactured until 1984. Rentschler then stated that there was no indication O'Keefe was struck at his center of mass or by a glancing blow, as the evidence and peer-reviewed articles suggest such a blow could not propel the body 7 to 10 feet. Again, another sidebar, and the judge announced a morning break at that point. After the break, Jackson concluded his questioning, asking if the biomechanical evidence supported O'Keefe's right arm being struck by Reed's SUV, causing a backwards fall and a head injury. Rentschler replied that the evidence was not consistent with this scenario, and the defense rested. The court recessed for an afternoon break. I guess you shouldn't say arrested, but had no further questions, to be more accurate. Anyway, Special Prosecutor Brennan then began his cross-examination of Mr. Rentschler, opening up with facts matter, as Mr. Rentschler had opined and expressed many, many times in his questioning on direct. So, good cross-examination, use their own words against them. Like I said, he opened with facts matter and questioning Mr. Rentschler's knowledge of the collision point of impact. Rentschler responded, nobody does. There's no evidence. And then Brennan pressed on as if Rentschler had spoken to anyone about prosecution experts. Dr. Judson Weltzer's testimony, to which Rentschler replied he had not. Brennan's cross-examination continued, focusing on a lunch that Rentschler had with the defense team after testifying in the first trial, and he described eating a ham sandwich and standing in a corner afterwards while waiting for his ride, stating he did not talk much, but may have laughed during the conversations. Now, Brennan probed further, asking how long Rentschler was at the table, to which he said he couldn't recall. Brennan also asked if Rentschler and the defense team discussed portraying him as an independent individual during the first trial, which Rentschler denied. Now, when the attorney doing the cross-examination is asking you these questions and he's asking you to admit or deny that this took place, and he said, oh, by the way, there were camera crews there, and oh, by the way, we probably got those interviews. So I'm expecting something in the case in rebuttal by the prosecution of showing the good doctor yucking it up with the defense, because those questions were not asked just because they were asked with a purpose. Anyway, the cross-examination grew combative as Brennan questioned Rentschler about studies he had conducted, confirming they were published over 2 decades ago and focused on wheelchairs, walkers, and smart technology for aging, not pedestrian accidents. And Rentschler clarified discrepancies between the 2 numbers used in the analysis by him and another ARCA expert. The 2 individuals, the attorney, Mr. Brennan and Mr. Rentschler, sparred over whether injuries can vary between crashes, with Brennan demanding a succinct answer, and Rentschler responded quite evasively several times. Now, I get it. The expert witnesses always want to let everybody know they are the smartest person in the room. I get it. But you lose credibility when you slice hairs so thinly on things that don't matter. Just say, yes, I agree. That's called credibility. Agree with the person cross-examining you. I talk to experts about that all the time. You don't want to look like a pompous ass on the stand. If it's an obvious question, injuries can vary from accident to accident, right? Some people can be completely devastated in accidents. Sometimes people walk away with no injuries, and you cannot believe that happened. Just state that. Otherwise, you look like a pompous ass. Anyway, when Brennan asked about plastic shattering, and Rentschler remarks, I've never seen a case where you can get these types of abrasions. Laughing, Brennan sharply responded, is that funny? The defense objected. The judge sustained those objections. Next question, Mr. Brennan. No more comments. Brennan then asked about the Welcher's test, Mr. Welcher, Dr. Welcher, where Welcher painted blue paint on his arm and was hit by a vehicle identical to Miss Reed's. Rentschler called the test meaningless if it did not aim to recreate the crash, prompting Brennan to retort, now that you've shared your opinions, can you get back to my question? The defense objected again, citing editorializing, leading to yet another sidebar, and then we broke for lunch. And that's when we're doing this, ladies and gentlemen. So the cross has continued. Check it out. We're bringing it to you live here today. You'll be able to watch the entire thing. I know I'm going to be watching it, even though when I get done with this, I got to fly over to the western part of the state for an early morning court appearance tomorrow. So I will be watching it this evening as well to bring you my comments tomorrow. Next, the Lori Vallow case. Lori Vallow is trying to get the judge yet again on her case thrown off. Apparently on Monday, she filed yet another motion calling for the recusal of Chief Judge Jennifer Green. Now, Green is a judge who denied Lori Vallow's motion when she called for the recusal of Judge Berensky. Not once, not twice, but 3 times. Anyway, Daybell also filed a motion requesting a hearing to dismiss the case for an abuse of discretion. Now, because the motion alleged that the division cannot be fair, the motion will be assigned to an associate presiding criminal judge. Anyway, Judge Kevin Ween was assigned the motion, and he denied both of them promptly. Apparently, under the rules there in Arizona, Rule 10.1b1 provides that a party may not file a motion after a hearing or trial begins. A jury was impaneled in the 2022 matter on June 4th, 2025, and trial in the 2021 matter has concluded. These motions, therefore, are untimely and therefore denied. Next, Sean Combs. This dude is a freaky, weird dude, if you believe what is testified to by the witnesses. So another ex-girlfriend details an NBA-themed freak-off. All right, this is a family show, so if you got small children, maybe you want to close your ears, all right? Close their ears. Anyway, in the federal sex trafficking and racketeering trial of hip-hop mogul Sean Diddy Combs took a dramatic turn as his former girlfriend, testifying under a pseudonym of Jane, revealed some graphic details of their relationship on the second day of the 5th week of trial. Now, in testimony that apparently was captivating the entire courthouse, Jane described elaborate sexual events dubbed freak-offs, which allegedly involved NBA-themed role play, with Combs portraying himself as Michael Jackson, Jane as Kobe Bryant, and a male escort named Paul as Shaquille O'Neal. Jane, who dated Combs from 2021 until his arrest in September of 2024, testified that these drug-fueled encounters, often lasting over 24 hours, were orchestrated by Combs, who directed her and the escorts while observing. She suggested that Combs' fixation on cuckold scenarios, where he watched her with other men, was a way to explore sexual fantasies indirectly, as he was too ashamed to engage directly with men. I would use the word cuck for him, Jane stated, explaining her research into the term understanding his desires. Now, the prosecution alleges, obviously, that Combs used his wealth and influence to coerce women, including Jane, into participation in these events. Now, Jane claims that she felt obligated to comply because, well, he was covering her expenses, paying her $10,000 a month, a point the defense contested. She also alleged that Combs nicknamed her crack pipe due to his intense sexual fixation, and so showed signs of drug-related health issues, including graying gums and possible jaundice. Well, the defense attorneys, needless to say, challenged Jane's narrative, presenting affectionate texts and an audio where Combs called her crack pipe to suggest consensual participation. Jane admitted to still loving Combs and enjoying nurturing him, prompting smiles from the defendant despite judicial warnings against reacting in front of the jury. The defense also sought to distance Combs' employees from the alleged crimes to weaken the racketeering charge, which requires evidence of a criminal network. Jane's testimony mirrors earlier accounts by ex-girlfriend Cassie Ventura, who described similar types of coercion. However, Jane's emotional conflict over Combs' polyamorous lifestyle and her sympathetic initial participation adds complexity. I want to please him, she said, but later found the imbalance in their relationship as trauma-inducing, dismissing the defense claims receiving luxury gifts like Chanel bags with, "No, I only got trauma." Well, Combs faces charges of these allegations of sex trafficking, racketeering, conspiracy, and transportation of prostitutes over state lines. He's obviously pled not guilty. That's why they're in trial. The trial is now in its 24th day, and it continues to unravel a web of allegations against the once celebrated music icon, with potential life imprisonment at stake if he's ultimately convicted. It's weird, ladies and gentlemen. I mean, the real question is, listen, they're not saying this stuff didn't happen. The defense isn't. They're just saying it was consensual. And if it's consensual, is it criminal? Probably not. That's what the defense is going to try to convince the jury to believe, and, try to get a not guilty for their client. Next, some low-level YouTubers settle their dispute. 2 are dead, and 1 is probably going to prison for the rest of his life. So a prolonged online feud between 2 YouTube streamers in Las Vegas escalated into a fatal shooting outside a resort on the Las Vegas Strip. Now, the conflict, marked by personal attacks and a reported pepper spray incident, culminated in the death of Rodney Finley, and he's known as Finny the Legend, and his wife, Tanisha Finley. Now, the alleged shooter, Manuel Ruiz, known as Sin City Manny, faces 2 counts of murder and is being held without bail. Now, according to the arrest reports, Ruiz claimed he acted in self-defense. I'd show you the video, but I don't want to get demonetized. YouTube won't allow it. You can decide whether it's self-defense. All right? Anyway, Ruiz claimed he acted in self-defense, alleging that Tanisha Finley was confrontational, and that Rodney Finley reached for an object in his waistband, prompting Ruiz to shoot. He also claimed to have seen a shiny black object in Tanisha's possession, which he may have mistook for a weapon. However, a mutual friend and fellow streamer reported witnessing the shooting via live stream, stating that Ruiz drew a gun and fired multiple shots at Mr. Finley. Police nearby responded to the gunfire, and Ruiz was apprehended after his wife informed authorities of his involvement. Now, the feud reportedly stemmed from competition over viewership and control of streaming locations in Las Vegas. Fellow streamers noted that Ruiz was losing followers to Finley, which intensified tensions, and Ruiz allegedly made derogatory remarks about Finley's wife and used racial slurs, further escalating the conflict. Now, a friend of Finley, a guy by the name of Derek Ware, recounted a prior incident where Ruiz used pepper spray on Tanisha, expressing relief at the time that the altercation did not involve a firearm. The incident has prompted discussions among the YouTube community of streamers describing the online rivalry and is a tragic outcome. Police continue to investigate the circumstances surrounding the shooting. These guys, ladies and gentlemen, were streamers as it relates to gambling, I believe slots. There's people there that have millions of subscribers in the slot area. I know. Who knew, right? It's a big deal. These guys, I think one had 41,000 and the other one had 14,000 subscribers. You would think, I mean, they're arguing over that little small bunch, really? And they can't, I mean, it's who's got the better content? Isn't it really what the situation is? And if you got to do content strikes and badmouth somebody, clearly it shows that, well, you probably don't have any talent, because at the end of the day, the cream of the crop will rise to the top. And that's just the way it is. You have to put out a product that people want. And if you're only getting those small numbers and you have to go harass some people, you think that's going to get you viewers? I mean, that's just ridiculous. Ridiculous. Next on the docket, a school counselor finds out her fate. Emily Nutley, a 43-year-old former counselor at St. Xavier High School, apparently a quite prestigious Catholic boys' school in Cincinnati, Ohio, was sentenced to 3 years in prison for engaging in a sexual relationship with a 17-year-old student. During her sentencing at the Hamilton County Court, Ms. Nutley visibly and emotionally expressed remorse, acknowledging that there was no excuse for her actions and that she had crossed a line that should never have been crossed. She pled guilty in April to 2 counts of sexual battery, each a third-degree felony. Court records reveal that Ms. Nutley had sexual encounters with the student multiple times, including in her office at the Jesuit school, where she was responsible for supporting at-risk students. She also exchanged nude images with the victim, providing him a monthly allowance and supplied answers on upcoming tests. The students reported that Nutley threatened to harm herself if he ended the relationship, which began back in the fall of 2023 semester. The victim, who sought a 10-year sentence, described the profound impact of the abuse, stating he was unaware he was being manipulated and continues to face harassment tied to the scandal. Prosecutors requested at least a 5-year sentence, described Ms. Nutley as having preyed on the most defenseless person she could find. A defense-hired doctor characterized her as a broken woman struggling with mental health and substance abuse issues. And Ms. Nutley herself acknowledged the severe personal consequences of her actions, including the loss of her husband, home, friends, and causing harm and embarrassment to her children. Her husband, Jonathan, filed for divorce shortly after her termination from the school in October of 2023, when the student reported the abuse. Now, in addition to her prison term, Ms. Nutley was ordered to serve 5 years of probation upon her release, and she's going to have to register as a Tier 3 sex offender every 90 days for life. Now, during the sentencing, she stated she did not expect forgiveness, recognizing that she had not earned it. I'm telling you, I mean, this stuff just seems so common these days. Maybe it happened when I was a student, but I was such a dork. I just don't know. All right, next on the docket, this day in legal history. June 11th, 1911, the United States Senate approved 64-24 the 17th Amendment, mandating the direct popular election for senators. As you know, prior to that, the states actually elected senators by their representatives. The state senators voted on who to send to be the national representatives there, and they were responsible to the people. Now, the people, but nobody ever gets voted out. What can you do? Next, June 11th, 1923, United States Supreme Court in Ridge County versus County of Los Angeles unanimously upheld government eminent domain powers for public use projects. That's right. They can take your land if they say it's coming for a public use. June 11th, 1963, Alabama Governor George Wallace physically blocked black students from enrolling at the University of Alabama. And then President Kennedy federalized the National Guard to enforce desegregation. That evening, President Kennedy delivered his landmark civil rights address advocating federal legislation. On June 11th, 1993, the United States Supreme Court unanimously approved enhanced sentencing statutes for hate crimes. And on June 11th, 2001, the Oklahoma City bomber, Timothy McVeigh, remember that guy? Well, he was executed by lethal injection at the United States Penitentiary, Terre Haute, Indiana. Next on the docket, our legal quote of the day has to do with plea bargaining. Plea bargaining is a necessary evil in our justice system, for it ensures efficiency, but risks eroding the pursuit of truth when coercion overshadows fairness. Now, that comes from the Santabella versus New York case, a 1971 United States Supreme Court decision that emphasized the importance of fairness and adherence to promises in plea agreements. Now, most people don't know this, but it wasn't until the late 60s there was no plea bargaining. You either pled guilty to the charge, right? Or you had a trial. It was pretty darn simple. None of this charge bargaining stuff that goes on today. And it's a mixed bag. Obviously, if you're the accused and you want to get a better deal, you hope for a plea bargain. Double-edged sword, I guess. Does the community get justice if they get these type of plea bargains to avoid the consequences of the original crime charge? Well, if they didn't have plea bargaining, the system would absolutely come to a complete halt. There's no way that they could handle a system like today and actually have trials on every case. It'd be simply impossible. Next, our dumb criminal of the day. A costly tinkle, the Sam's Club spam scandal. In a tale that equals part bizarre and revolting, a Sam's Club in Lady Lake, Florida, found itself flushing over $10,500 worth of canned meats down the drain after an alleged urinary assault. The culprit, a 70-year-old retiree named Patrick Mitchell, who police say turned aisle 18 into his personal porcelain palace. According to the probable cause affidavit, a quick-witted witness caught Mitchell in the act snapping a cell phone pic as he allegedly relieved himself on 2 pallets stacked with Spam and Vienna sausage. The savvy shopper alerted store employees who turned to the ever-watchful eye of surveillance footage. Detectives reported that the video showed a man siding up to the pallets, hands suspiciously positioned below the belt, lingering just long enough to suggest that he was admiring the canned goods' fine craftsmanship. Spoiler alert, the behavior screamed urination. Anyway, store workers confirmed the worst. The puddles of pee had defiled 188 bolt packs of Vienna sausage and 345 8-can sets of Spam Classic. The grand total, a whopping $10,584.54. Contaminated by bodily fluids, the goods were deemed unfit for sale and destined for the dumpster. Somewhere, a picnic planner shed a tear, but Mr. Mitchell, it seems, wasn't fazed by his alleged aisle-side antics. No, security cameras reportedly caught him sauntering through the snack section, lounging on patio furniture like a man without a care, and then casually checking out at register 2. Thanks to Sam's Club's membership card system, they identified the suspect. That was quite easy. By swiping his barcode. Anyway, a match between Mitchell's driver's license and photo and the witness snapshot sealed the deal. Police tracked Mr. Mitchell to his home in the Villages, a retirement haven billed as Florida's friendliest hometown. Friendly, perhaps, but not exactly fragrant in this case. The retiree, who once sold his Long Island digs for $620,000, now faces charges of disorderly conduct and felony criminal mischief, the latter due to the hefty price tag of the alleged pee party. Pleading not guilty, Mitchell is out on a $3,000 bond awaiting his arraignment on June 30th. So what drives a man to turn a wholesale aisle into a latrine? Was it a protest against processed meats, a dare gone horribly wrong, or just bladder with a vendetta? We may never know, but one thing is certain. In Lady Lake, the spam hit the fan and the floor, leaving Sam's Club with a cleanup job nobody signed up for. All right, ladies and gentlemen, that's all we have for today. Thanks for joining us. We'll see you next time. And remember, the Constitution matters.